Hey everyone, Jonathan Shaw here with another video on my favorite topic, immigration. If you're an H-2B employer who's thinking about hiring foreign workers to fill temporary needs, one of the most daunting aspects of the application process is probably understanding the employer's obligations. You, an employer, have already contended with a lot of labor and health law issues, and now that you're thinking about hiring foreign workers, you have yet another area of the law, immigration, to contend with. So how do you find out what your obligations are? Well, it turns out there's a single document called the ETA 9142B Appendix B that lists a very thorough set of employer obligations under the H-2B regime. Thorough as it is, and it is written in plain language instead of legalese, I actually think that document is a very poor way to learn H-2B employer obligation. It's not organized well. No thought was really put into how one item should follow another, how they should be organized into little sections. So if you just first heard about this, I invite you to actually look at that document and read from item number 1 to item number 26 and see if any of those make sense to you. I'm sure some of it will, but you're not going to really remember much of it. So to help all of the people who are new to the H-2B application process and who want to know about what they're on the hook for, I am going to, in this video, go through all those obligations. And I'm going to separate all of those obligations into 3 broad and easy to understand categories, because that actually was how I learned about those obligations when first starting out as a lawyer. Here are the 3 categories. Are you ready? First is you treat U.S. workers fairly. Second, treat foreign workers fairly. And lastly, be candid with the U.S. government. That's it. We're going to go through all the items under each one of those categories, and hopefully by the end of the video today, you can feel much more confident about approaching the H-2B visa. So how do U.S. employers treat U.S. workers fairly? The most fundamental principle of the H-2B visa is that the U.S. workers should get first dibs to all of the available temporary job openings. The pretext of the H-2B visa is that there are no workers that are able to fill the temporary vacancies, so the employers have to come to the Labor Department and make a specific request to hire foreign workers. The application process involves a very heavy recruitment step to test the U.S. labor market. This recruitment will involve a lot of different steps, such as job postings on both the state and federal Labor Department's websites, internal notices at the employer's place of business, contacts with former workers who have filled the temporary positions, and contacts with union representatives where applicable, if they exist. The certifying officer whose job it is to review those temporary labor applications can also assign additional recruitment steps. Once those recruitment steps are complete, the employer is now on the hook to evaluate in good faith all those applications coming from U.S. workers. In this context, the U.S. workers mean U.S. citizens, permanent residents, or someone holding a valid work permit. Okay? And if a U.S. worker applies because of the recruitment, they can only be rejected for lawful job-related reasons. This is a term of art. What is lawful and job-related depends on a whole lot of different things, and in fact, there is a specific government agency in the Labor Department whose job it is to evaluate this specific issue, I suppose in addition to many other issues, but this one is a big topic. But basically, employers cannot reject for reasons such as nationality, ethnicities, age, sex, religion, and other characteristics of the applicants that have nothing to do with how they perform the jobs. This is fairly simple. Additionally, employers should not implement, for example, really strict physical tests, such as being able to dash 100 meters in under 10 seconds. That would be close to, I think, over Olympic record, which was unreasonable. The employer can't set interview time at some unreasonable hours, such as 2 a.m. in the morning, maybe in person, even though the place of the interview is in New Jersey and the applicant is all the way out in California. That's a big no-no. Those are the basic stuff, and there might be other lawful job-related reasons with which that the employer can reject the worker, but this is something that they really need to think about or speak with an attorney about. Okay, so in the same spirit as U.S. workers getting first dibs, the employer also cannot try to hire H-2B workers to replace unavailable U.S. workers. For example, if there is a strike or a lockout going on, and that prevents the employers from hiring U.S. workers, they can't then go to H-2B as a way of hiring foreign workers to replace the U.S. workers that are lost. They cannot let go of U.S. workers before hiring H-2B workers. And if they need to let go of any one of their workforce, the H-2B workers need to go first. Once hired, the U.S. workers must also be generally treated fairly. So typical labor law issues would apply here. They must receive a fair wage and be given the appropriate benefits that are expected, the base minimum, depending on state and federal laws. Note that since H-2B workers would be paid a prevailing wage that is typically higher than the state or federal minimum wage, the U.S. workers must be paid the same amount for those same jobs as well. Next, how do employers treat foreign workers fairly? Well, employers first must, at the very basic, guarantee foreign workers work and fair wage. Employers should offer a bona fide job opportunity, meaning it's not fake. They must hire foreign workers to perform at least 35 hours of work per week. They should employ the foreign workers for the entire period of need, unless some catastrophe forces the employer to lay off their workforce. H-2B workers must be paid the higher of state minimum, federal minimum, or the H-2B prevailing wage as determined by the Department of Labor. They must be paid at least once every 2 weeks. Foreign workers should pay next to nothing throughout the H-2B process, from the moment they set foot in the United States to the moment they come home. Most of their expenses must be covered by the employers. Those include transportation into and out of the US, yes, that includes airfare, tools, supplies, and equipment, fees to the immigration attorney and any recruiters whose job it is to connect the employers to those foreign workers. And any immigration petition and visa fees are also covered by the employer. Notably, employers are not obligated to provide lodging, but many do as a practical matter and make reasonable deductions from the worker's salary because of it. The employers must inform foreign workers of their rights. This would include a poster posted at the place of work that details the H-2B workers' rights. In fact, the Labor Department supplies a Spanish version for the employers whose workers mostly speak Spanish. Copies of the job order used to recruit U.S. workers, remember that, must be provided to foreign workers timely once they are hired. Why? To ensure that the foreign workers understand the terms of their employment. Lastly, the employer should be candid with the government. How can they do that? It should go without saying that all forms submitted to the government must be accurate and thorough. Employers should honestly present their temporary needs, the number of workers needed, and the duration the workers will be hired. Employers should keep a thorough recruitment report that documents all the U.S. worker applications they received, as well as the lawful job-related reasons that the workers were rejected. This recruitment report is not only submitted to the Labor Department as part of the application process, but it also must be kept in the employer's place of business as a part of their audit file for 3 years in case of any random audits from the Labor Department later on. If any foreign workers depart work earlier than planned, the employer must inform the government. H-2B employer obligations may seem complex, but they don't deviate from the 3 principal tenets I just mentioned. Treat U.S. workers fairly, treat foreign workers fairly, and be candid with the government. If an employer can do all 3, they are well on their way to reap the benefits of the H-2B visa and build their business. And that's it for today, guys. We are Shell PLLC. We are an immigration firm based in Washington, D.C. We emphasize honesty and thoroughness to deliver the best results for our clients. If you have any other questions about the H-2B visa, and you might now, because if you're thinking about hiring people in the winter seasons, now is the time to start. So go ahead and contact us by phone, by email, or visit our website and use the contact form. And just let us know, hey, I'd like to know more about the H-2B visa. How can I get from step A to step Z? And I will be very, very happy to talk to you. Okay, see you next time.